Good afternoon and welcome to our discussion on smart GovCon business transfers, new SBA regs and tax. So I know we have a lot to get through today, so I'd like to quickly introduce you to our panel. Our first speaker, Sharon Heaton, is the founder of sbLiftOff, a national M&A advisory firm which serves owners in the government contracting space. Sharon has advised on transactions totaling more than $12 billion in deal value and focuses on bringing high-quality M&A advisory to the mid-market GovCon space. Sharon just released a second edition of her book, Liftoff, 12 Things to Know Before You Sell Your Company, published by Forbes and available on Amazon. Appointed to the Small Business Administration's Investment Capital Advisory Committee, she works nationally to increase small business access to investment capital. Next, we have Joe Cope. Joe is the founder of Cope Connelly Family Office, based in Arlington, Virginia. Joe has spent over 20 years helping entrepreneurs, many in the GovCon community, solve complex tax, estate, business, and wealth challenges. These challenges include reducing tax on M&A transactions and allocating wealth both publicly and privately. Over the next hour, we encourage you to submit questions throughout the Q&A option at the bottom of your screen. You can submit questions throughout the presentation, and the panel will make every effort to answer your questions. So let's get started. Sharon, I'll turn it over to you.
Fantastic. I'm delighted to be here today with my friend Joe. I think that we've got a lot to talk about.
We do.
As people in the audience may have heard, stuff's going on the GovCon market. It's not been as slow and steady the way it's been in the past, but certainly the last 3 or 4 months have seen more change, more rapidly than I think that we've seen in quite a while. So I think it's really important that we do discussions like this. Joe, what's your reason for wanting to do an event like this now?
Well, I think it's these issues we've seen in the last 3 months are in some ways insulated to our community, the GovCon community. I was just on vacation in early March with my family and was sitting across the pool. We have young kids with another father. He was from Philadelphia, and he found out I was from DC. He said, "How are things after?" And I was like, all the things, right? He said, "After the plane crash." And I was like, well, yeah, no, that was very tragic, but there have been some things happening in our city, in our community that were much more dramatic. So I think coming together for those of us who are most impacted, and we got to talk about these things, right? And I think anytime I can do that with you, especially Sharon, we got to do it because we're all in it together. We're finding ways through it, but it's definitely unique to GovCon.
Completely agree. With the tariffs, I think it's having more of an impact outside of GovCon,
Yeah.
but GovCon has its own issues. I
Yeah.
have to say that at the beginning of this year, I really expected that the new SBA rule that
Agreed.
affected M&A was going to be probably the biggest thing that affected GovCon in 2025.
As did I. As did we all.
That's one of those, humans plan, God laughs.
Yeah, that's right.
That turned out to be not at all true.
Uh-huh.
We're dealing with companies that are really dealing with existential issues. So let's
Mhm.
talk about that just a little bit. Before we get into how to sell your company, how to buy your company, let's talk about the GovCon market a little bit itself.
Yep.
Because while there's a massive amount of change going on and people are definitely being impacted, there are some constants that haven't changed, which is that the government relies upon privately held companies, publicly traded as well, in order to do much of the work of government. And in fact, with all of the downsizing of government employees, it's likely that that's actually going
Yeah.
to pick up. Now, can I tell you when that's going to happen or whether or not we're going to have another round of cuts? No, I can't. And if anybody tells you that they can, please leave the room. They're lying to you. There is not visibility that we have. However, we can see some long term trends. And those long term trends are that government contractors actually make the work of government more efficient.
Yeah.
There do seem to be some contract areas that are more likely to get cut. Certainly, we saw what happened with USAID. Consulting seems to be a negative word these days. But there are a lot of folks who have had no impact whatsoever. In addition, people who've had an impact, the impact is on page one of the newspaper, but a week later, some of those contracts are reinstated.
Yeah.
And that's not on the front page of the newspaper. So, I think that what we're seeing, and Joe, I'd like to get your take on this, is that people who are part of the GovCon market kind of are just focusing on resiliency and perseverance to get to the other side of this, kind of like they did in sequestration or when there's a government
Yeah.
shutdown, but that there's life after this. Joe, what do you think?
I think the psychology of most of our GovCon clients that we've talked to has been survive and then thrive afterward. I think they're seeing the bright side as long as they weren't on the first kind of cut of DOGE. There were some impacts. We've seen clients lose contracts. We've seen them get them back. They've made arguments. They've talked to their COs. They've found ways back on those contracts. I think I had a client conversation yesterday that nearly all his pipeline for this year, the big push was into GSA, and it was gone. And I talked to him in February. We were going to do some work together, and he said, Joe, I need to regroup. I said I would be doing the exact same thing if I was in your shoes. Right? You have to regroup. He's on solid footing, and we're moving forward. And that was only a month and a half pause of agony, but it was enough to kind of, I think, see where the dust has settled and to see where the opportunities are, right? How do we move forward? So I think I think GovCon is filled with very resilient people. I don't think they give up very easily at all, if at all. And they're finding ways to find the silver linings and the opportunities in this thing, which I think to your point, Sharon, is that the government's going to rely on contractors more. We are downsizing and we need services. So I think that's how I've seen this thing play out. That's what I've been hearing on the street, is that there's more opportunity coming for those that can make it.
Let me share something that we're seeing at sbLiftOff that's a little bit surprising. Generally, when you have this level of change, the market might freeze up.
Yeah,
Sellers
we
wouldn't
expect
go to
that.
market, buyers would run for the hills. That's not what we're seeing. We're seeing some sellers being pretty eager to go forward their transactions because it's the right time in their life, because it's the right time in their portfolio. Let's be honest, a government contracting company
Yeah,
is simply a portfolio of its contracts.
yep,
And you want to go to market when you have a lot of backlog, and
yep.
you don't want to go to market when you don't. So there's a life cycle to these companies, and there are
Can I
definitely
ask
people.
you a question about that? Because I think that's what the SBA regs in January made us very concerned about, which, if you're not familiar, there's a lot of good content out there. Steve Rumeli of Miles and Stockbridge has done a great job putting out a lot of content. I know you've done some work, Sharon, on some of these blogs, but we expected, I think, there was some significant rancor. These SBA regs came into effect in January, delayed by 1 year. So I think it's like January 16th or 17th next year, they're going to come into effect. And I would say from an M&A standpoint, an SBA, a small business value standpoint, that we were at, what do you think, Sharon, a 9 of concern and belief that if you were a small business, that 2025 was your year to sell. We were like, and now we've had some more time to digest it. And where are we now?
Excellent question. You are completely correct. When this first came out and I read the rules, I was at a 9,
Yeah,
saying, "Oh my gosh, you can't exercise option years."
yeah,
But then we stopped and we actually talked to the SBA and we said, "What did you mean by this?" So let me put a little bit of context in this. If you're a company that's working in the set aside market, and you sell to somebody, there's going to be a recertification within 30 days of doing that transaction. If the buyer is able to recertify that they meet all of the set aside standards that you did, woman owned, hub,
yeah,
whatever it
that's
might
fine.
be, then everything's fine. You have a qualifying recertification. But what happens if the buyer can't exercise all of those, can't qualify in all of those set aside categories? So, hypothetically, and the major concern really was a PE backed company that's large acquiring a woman owned small business, SDVOSB, and historically, the buyer was able to continue to exercise the vehicles that were there. The government wouldn't be able to take credit for it, but they would be able to get more work. The SBA rules seem to say, wait a minute, if there's a disqualifying recertification, then the buyer would not be able to keep the work that the seller had.
Yep.
Upon reading it more carefully and speaking with the SBA, the rules have become a little bit clearer. The significance is that if you have a multiple award vehicle and it's in a set aside category and you sell to somebody who doesn't meet that set aside category, they probably won't be able to get more work under that vehicle. Now, that's actually been true for a lot of the IDIQs and the big contracts for a while. So T4NG, for instance, had a provision like that. But they're basically saying we're putting that out. The part that was a 9 on the scale for me is that it seemed to say that if you had any task orders under those contracts, you could finish out the period of performance that you were currently in, but you couldn't exercise the option years for that task order. Over time, the SBA has made it absolutely clear that any task orders that have been granted, that have been awarded prior to a transaction, continue to be awarded even after a disqualifying recertification. So, what you're losing is the upside potential from the vehicles that you may have that are multiple award vehicles, but you don't lose what you already have. That changes this from a 9 to, let's say, a 5 or a 6.
Okay,
Is it clearly a complication? Absolutely.
correct.
Is it the same kind of hair on fire that we thought? No. And as a result, it's kind of a push pull. I thought this SBA rule would really impact sellers saying, I need to get to market before this rule fully goes into effect in January of 2026. And there's definitely some reason to be looking at
Yeah.
your contracts and seeing if it makes sense.
Okay.
But there are so many other factors that need to go into play here. And I want to do a little bit of a pivot because one of the things that I say to clients all the time is there are two things that need to be ready if you're going to sell your company. One is your company, and we can talk about that at length. But second is you as a business owner. You as a business owner need to be ready, and you can't be doing that at the same time that you're going to market. Joe, what are the kinds of things that business owners should be thinking about before they put their company on the market?
That's a great question. So I think it's where we'll probably spend a lot of our time here, Sharon. I'll bring up a slide here in a moment. So again, if you're who does what here? So Sharon is an M&A advisor. She does phenomenal work. I think giving you advice on whether your company is ready to go to market, what a general value of you could expect to go to market for, what would be some of the upside of your company, maybe what are some of the downsides, right? This is a little dose of reality that we all need to know what we got, right? And so I'd really suggest to have a conversation with Sharon to understand where things are, and maybe you could even work if you're in the at least get the relationship established that you know when you're ready, you'll have someone in your corner. On our side, the other big factor that I think I see a lot of business owners struggle with is that they've been head down in the business, working on it, growing it. I kind of joke that nobody believes they have anything of value until someone writes them a check. They won't admit they might have something of value. So I find that when an owner can look up a little bit and say, you know what, I think I've created something of value, and I want to make sure my family's taken care of. I want to make sure our planning is done. Sharon can get you the best sales price. My job in our family office, our work is that you get to keep the most amount of money both today and your family in the future, right? You haven't done this just for yourself. You've done this for generations. So we take a very, I think, a creative approach, a unique approach. So we're going to talk through two different sides of the tax coin today. One is called on the estate or gift tax front, planning that you should be doing in advance of a transaction. This planning can be done up until the day you get an LOI. We're doing that right now. We just got brought in late on the deal. My preference is, 6 months, a year in advance. You get me 2 years, it can be even better. But again, we can kind of do anything. So it's going to be on the estate and the gift tax side, and then also the capital gains tax side. There's some kind of pretty unique strategies there. So if it's okay, I'm going to go ahead. Or Sharon, you want me to share my screen now, or do you have
Yes,
another
please.
thought?
While you're bringing that up, let me tell a story.
Sure.
I was working with a business owner who had a very nice company. And I turned to him before we put the company on the market and I said, Harry, I think that, you need to do some estate planning here. And he said, absolutely not. I said, well, you're a C Corp. There's a wonderful provision called 1202, but you're not going to comply with that. So a C Corp is going to raise all sorts of issues on a tax basis, and you're going to pay more taxes. Do you want to deal with these issues in advance? And he said, no, absolutely not. We got a letter of intent. He signed the letter of intent and then turned to me and said, what do I do about tax planning? And I said, well, we create a machine to go back in time to before you signed that LOI, because these are some of the things that needed to be done prior to that LOI. In fact, for people who are thinking about changing their home state, maybe it's
Yeah,
Florida or some other place that's a
yeah.
zero tax capital gains state, don't do that in the same year that you're selling your company. You want to put a little bit of distance on. So, Joe, if you would pull up your slide and walk through it, I'd
Yeah,
appreciate that.
I can definitely address both those ideas. So you look, planning for taxes, once you have an LOI in hand, we know what the potential value of your company is. So it's very difficult to tell the IRS with eyes wide open or find a CPA who will agree that your company is not worth that. Prior to an LOI, though, we have a lot of flexibility with the valuation of your company, mainly because we can apply certain types of discounts to its valuation. And for the purposes of estate planning, we actually want your company to be as low in value as possible. This is not an exercise where we're going to talk with Sharon and say, you can get this. We actually want it to be as low as possible for the purposes of transferring shares out of your estate, protected from estate taxes, which we'll talk about here in a minute. So on the left-hand side, we're going to talk through pre-sale estate planning. The strategy is that if you have created something of value, there exist these things called federal, and some states have gift or estate taxes. And what that simply means is that in your lifetime, if you try to give money away, or at your death, if your value of your estate is above a certain threshold, that the federal government will tax the amount that is above that threshold at 40%. Okay, so just to do the quick math, is that if the current threshold is $14 million, if you were to die with a $20 million estate, there is $6 million that is exposed above that threshold at 40%. That is a $2.4 million check that your heirs would have to write to the IRS, to the federal government, to the Treasury, having created no value. That's just simply a check that you have to write. Okay. So right now, that exemption that we have is $14 million per spouse. So you can give $28 million total. And that's a pretty big number. For most people, not a problem. You can get most of your wealth, to your heirs. The problem is that since I started in this business 21 years ago, there have been 5 different exemption amounts. And most notably, the administration that had been running in November that didn't win had drafted a proposal through Senator Warren to bring the exemption from $14 million all the way down to $3 million a person. Now at $3 million a person, you're really getting into some significant exposure. So while the exemptions are high right now at 14, and by the way, they are getting set to sunset at the end of this year down to $6 million a person, I think they're going to try to make this $14 million stick, or somewhere in that between those amounts. I think we're going to get something in between, is that they can be changed. And I would expect to see some significantly different and likely lower estate tax, gift tax exemptions in the future. With that said, if you make a gift to a family member, to a spouse, we do some planning today, you are grandfathered in under whatever the exemption amount was at the time you made the gift. So if you make a $14 million gift to your family, to your spouse, to your kids, you are now fully sheltered. Those assets and everything that is going to grow into is fully sheltered for your lifetime, for your kids' lifetimes, for your grandkids' lifetimes, and potentially up to 365 years. It is all that wealth is now outside of the estate tax regime, whatever it turns into.
And Joe, let me ask you a question on that.
Yep.
I'm assuming that what you're saying is if you create a trust that complies with the appropriate rules of whatever state or federal government, and it stays there, then it can be for hundreds of years. It's not as though you're going to do a gift of $14 million in cash, and then that cash, is tax-free from an estate tax forever. Am I correct about that?
Correct. So the type of planning we're talking about is the usage of irrevocable trusts. Okay, now there are 2 different types of trusts. There's revocable and there are irrevocable. Most people have some type, or those that have done their basic estate planning are the ones that have set up revocable trusts. So if you went to your local estate attorney and you have children, you said, hey, look, we need a will, we need guardianship for our kids. They very likely gave you a revocable trust. They gave you a springing power of financial and health springing powers of attorney, that you have a living will, which is basically what you want your end of life treatment to be. You sign those documents, you forget about them, you need to update them about every 5 years. Okay. Revocable trusts are good for the avoidance of probate. They are not good for the avoidance of estate tax. They do nothing on the estate tax. Okay, so we're talking about estate tax avoidance, which then leads us to the irrevocable conversation. Now, the word irrevocable is a very unpleasant word. So for any business owners out there, to set up a trust for the benefit of their lovely spouse, who I know they love, and then to put their assets into a trust that is irrevocable, that they can never get back once they make that, even if it's for the benefit, even if they love their spouse and their kids, is a very, very, very long bridge to cross. In fact, I find most people will not do it. Okay. So the uniqueness of planning that we engage with our clients rests in this very fact. And there are not all irrevocable trusts are created equal, and not all states and their rules are created equal. In fact, DC, Maryland, Virginia are very unfavorable states in which to do irrevocable planning, because the word irrevocable really means irrevocable. There are other more favorable jurisdictions in the US. They are Delaware, Wyoming. I have them listed here. Delaware, Wyoming, South Dakota, Nevada, Alaska. Florida's trying to get in the game, though they're behind. Those states are what are called self-settled jurisdictions. And what those states permit, not saying you want to do it, but they permit you to do it, is that if you make a gift to your own trust, you are a grantor of your trust. You put the gifts into an irrevocable trust, that per those state laws, you are permitted to add yourself back as a beneficiary to your own trust. So what that means, and I'll give you a simple example. If you set up a trust, you put your assets and your shares into of your company. Let's just say that's kind of a basic concept here. You put them into the trust for the benefit of let's say your wife, and your wife predeceases you. You will then, in most states, DC, Maryland, Virginia, those assets would go to your kids, and there's no takesy backsies. Whatever you put in there is now at your kids. There's rules around that. They're not just being handed the money, right? But still, in these self-settled jurisdictions, you could add yourself back to your own trust and get access to those funds again. Very important.
So looking at the slide that's on the page, on the left side, we're talking about pre-sale estate planning. Is that the favorable jurisdictions you're talking about on the left? That is where you can create an irrevocable trust, but in that irrevocable trust, you, the grantor, can be a beneficiary.
Correct. You can be added back. Now, there's some rules. You don't want to do this. It gets added back to your estate. We undo some things, but the flexibility, the undo button, or the flexibility is there to be able to do this planning with the understanding that if something materially changes in your life, that you have access to those funds in the future.
Okay, so hypothetically, and nobody wishes this on anybody, a husband and wife have a business, they create a trust. The husband is the grantor for sexism purposes.
Sure.
And then the couple gets divorced. So there's an irrevocable trust. The husband is the grantor. The husband and the wife are the beneficiaries of that trust. They have a divorce. Does the wife, under that circumstance, still get to take under that trust, or could the husband change the terms of the sharing between the husband and wife? Former husband and wife.
This is a great question, and it's a nuanced question, but it's an interesting marriage question. And I laugh because there are always these conversations you have around money. So typically, the way these trusts 50-50, sometimes they're set up with a named spouse. Well, let's just say the wife has the business and she has the wealth, and the husband is the beneficiary. The irrevocable trust can be set up with the husband as the named beneficiary, or we can have a husband or a spouse as a floating beneficiary. So as long as the wife is married to the husband, or he is the spouse, he has access to the funds. If he were to leave her and he is no longer her spouse, he no longer would be a beneficiary of the trust.
Interesting.
So there's impetus to stay together. And I think that's actually interesting. It's an interesting little wrinkle, but we see that a lot, is that if one partner had created the wealth and the other partner's benefited, or vice versa, how people see it, then the floating spouse provision adds a little bit of protection, especially if they're weren't any prenups or things like that. It can add an interesting wrinkle in the planning and give some additional comfort and flexibility, because otherwise people aren't making these irrevocable gifts to trust. It's just not happening. So it gives us, again, more flexibility. Now, one point I would like to note is that if I set up a trust, I put shares in a trust for the benefit of my spouse, and I stay married, you have access to everything that's in that trust just through your spouse. So the money's not going anywhere. It's just there's a conduit from which it comes out, right? It's only these other more dramatic death, divorce things that you might need to be added back to change. Okay. Now, good.
So let's say that a business owner is 3 to 5 years from selling their company, because that's what almost every business owner says to me. I'm
Yep.
not ready to sell my company today, but in 3 to 5, no more than 7 years, I want to sell.
Sure.
When should they be thinking about this pre-sale estate planning? When should they be thinking about the capital gains tax reduction options?
So the pre-sale estate planning, it can be done at any time, right? At any time you believe you have a company of value that you want to sell someday. And here's what's really important. It's this $14 million number. So I oftentimes will see clients that have values of companies, they wait to do this planning, but their company is now worth above $14 million. It might be worth 25 or 30, right? And now you can't move the entire company's shares into a trust. Now there's going to be a bunch of exposure outside the trust to the estate tax. So the earlier you can do it, the better. That's number one. Number two reason for that is that we can apply valuation. So even if your company is worth $25 million today, in order to put something in a trust, you need a valuation. That valuation is not for sale purposes, it's for estate and gift purposes. So we're going to apply usually around 35% discounts from its fair market value. So if you go from 20 million down to 12 or 13 or somewhere like that, now we can get the majority of shares into the trust, protected from the estate, and you have the flexibility to do it having used these jurisdictions. Okay. Now, two things I think are very important about these jurisdictions. Number one, you have to have a reason to do estate planning in these places. Why don't you? So you need to use an attorney that's domiciled in, that can practice law in there. Really, that's really important. The quality of those documents is extremely important. I've talked to many attorneys who are in these states that are not qualified to write the types of trusts we're talking about. They're very complicated. They need to have been done before. Number two, they're not cheap. When you pay for these states, they tend to be a little bit more expensive. And then you also need to have some type of trustee or connection to the state in order to have a trust there. So that could be a person that you know that lives there. Hopefully they're a trusted friend or colleague or family member, even better, that would be in those states, or we can use a trust company. And there are certain states that I have preference to in terms of their trust companies. Okay.
Okay.
Now, I think
that is.
Okay.
Go ahead, Joe.
Well, I was going to say, look, there's more technical concepts: grantor, non-grantor trusts, completed, incomplete gifts. I'm not sure this is actually the best. We could talk through those, Sharon. I don't think they're super pertinent. I'd rather kind of maybe move to capital gains. But again, if people have more questions, they want to come down this rabbit hole a little bit deeper, we could probably do that together on a separate call.
As a recovering attorney who took trust
right.
and estates planning,
that's right, you did.
The rule from my professor was hunker down into the masses. Don't do anything that kind of is going to call attention to yourself. So you don't want to be creating new pathways.
Correct.
But everybody's situation is different. And don't simply look at a newspaper article or even a treatise and say, I now know what to do. It is well worth talking to experts on that. Joe, you basically are dealing, your clients are people who have GovCon companies or have sold GovCon companies, and they're asking you to help manage their family's wealth.
Yeah.
What are you saying to your GovCon companies who have been impacted by DOGE? What kind of advice are you giving them?
You're saying those who have lost contracts or that are still practicing? Look, I think that as it pertains to this planning, most of the contracts, most of the companies we've seen have not, and thankfully, and I'm so sorry for those that were USAID or that kind of got wiped out. I think people have just kind of felt it around the edges, the people that I've worked with. So I've said, look, again, I think we chatted about this. Just stay the course, let the dust settle, figure out where you are. And once you have a good feel for that, you feel on your recompetes, you feel like you were maybe in December or somewhere close to that, then we engage in this planning, right? We'll go forward with it. But if you're still really wondering, I've a client out there right now, they're just in it. And we were going to do this work early, another one in January, February. And he just said, time out. Said, look, let's come back to this in 6 months when you guys, again, you feel solid on your valuation. No, nothing's ever perfect. It's never, I talked to some really successful individuals, and only after they sold their company, and even then did the feeling of someone's going to come in and take it all away finally dissipate. And this is before DOGE, right? Like that eminent feeling of this is all going to come crashing down at any moment has been there with people who have a few $100 million companies. It is an honest, and you can kind of have that conversation. They're having an honest feeling. Very successful people are like, I'm going to walk in and someone's going to have just taken the rug out from underneath me. So we're all doing this planning with a 10% underlying discomfort. And I think if that's okay, if we can be at 10 or 20, we can do the planning.
I think it's also fair to say that the value of your company has an impact on the kind of planning that you do.
Yeah.
If you have a company that you realistically think that you're going to be selling from $5 to $7 million, that's very different than the kind of planning that you'd be doing if you're going to be selling at 30 or 35. So having some sense of that would make a difference. I do want to talk about the DOGE effect on the M&A market, because as I said earlier, the M&A market hasn't stopped by any means. I think that in the larger deals, things are holding off this point, but in the under $50 million transactions, they're definitely going forward. Here's what's happening, however. Values for companies in the that have designations in the set-aside market, vary depending upon what the company has, their margins, the kind of work they do, all sorts of things. But if you were to look at it as a rough multiple of adjusted EBITDA, it's going to be somewhere between 3 and 6, and there'll be structuring involved and all sorts of things. If you're in the full and open market, you could be starting at 6 and go to 10 or 12 or 14. So clearly there's benefits to being in the full and open market from a valuation perspective. I don't think anybody in this phone needs to be told that. Right. The issue is, how do you go about buying a GovCon company when you've got the uncertainty of DOGE? And what I'm finding is that valuations for sellers are not going down, but the structure of these transactions is changing. That is, if you own a company today, you have the risk of DOGE. You have the risk that they're going to come by and do something to your contracts. And if you sell your company, you're not going to be transferring 100% of that risk, because a buyer is not going to accept that risk. And oh, by the way, you're not increasing your risk at all. So what we're seeing is valuations are about the same, but the cash at close has gone down a little bit, and there's more seller financing. And that seller financing has a bit of a clawback provision for a DOGE impact. So hypothetically, a seller sells their company and they've got $100 million of backlog. Buyer puts cash on the table, gives them a seller note, and the 100 million comes to pass, everything gets paid off, it's fantastic. But let's assume that that 100 million gets cut by DOGE and it's now $90 million of backlog. Well, the buyer and the seller are going to share some of the economic hit of that that $10 million loss in backlog. And that's fair, because had the seller not sold, that seller would still have $90 million in backlog, not 100. So it's not increasing their risk at all. But it is something that's pretty important for buyers to say, I'm willing to go forward with the transaction, but I'm not willing to take on DOGE risk. Have you seen anything like that, Joe?
Yeah, I think I have. And I think that's a really good point, Sharon, is that the terms, I've seen more seller financing at bigger percentages. And I think that's a very unique way to handle, an honest way to handle DOGE, an unknown quantity, that unless you're going to wait a few years, and if this thing, is put to bed or they've moved on to some other, target, some other place, and the risk's gone. But as you started the call with, you have a 5-year backlog, it might be time to go and you want to sell, right? You can't wait till you have 2 years of backlog. DOGE is no DOGE risk, but now you have to wait for your recompete. So in GovCon, there is timing. So I think the structure of the deal, the art of the deal, Sharon, which obviously you're seeing on a day-to-day basis, I think what you just said would be a fair outcome. the client asks, hey, Joe, is this fair? Yeah, I think that's fair.
Okay. So preparing yourself and your family for a business sale.
Yep.
Okay. We've talked a lot about the pre-sale estate planning, the capital gains tax issues.
Yep.
Obviously, there's a lot of information out there about how do I prepare my company to go to market, and
Yep.
I'm happy to talk to people about that at length. I would like to throw out that we do have a Q&A option for people. So if you've got any questions, please feel free to put them there, and Joe and I will take our shot at trying to answer them. We talked about DOGE, the new SBA regs, and the impact on M&A. That really comes down to that recertification. And it is so new that nobody fully knows how it's going to work. Some of the rule, in fact, did go into play in January of this year. Most of it goes into play of January of 2026. And one of the new things that's in the rule is that if a company that is small prior to a transaction acquires another company that is small prior to a transaction, the combined entity, even if it sizes out, will still be able to use all of the vehicles of both the buyer and the seller. That is a new benefit that exists only for companies that are in the set-aside market. It is a significant change, and it's one of the advantages being given to small businesses. Joe, do you think there'll be much activity in that range?
I hope so. I think that would be, I mean, I think the regs, when they came out again, we were all about a 9. I think there were some positives in there. I still think 2025 is probably a better time to transact, but I don't think it was the end of the world if we're in 26 as well. So I hope to see it. What are your thoughts on that?
I think that the timing is important. 25 has some benefits, 26 will have some benefits as well. But this new small buying small deals with what I think is one of the flaws of the market, which is a lot of business owners will be in the set aside market and bring themselves to the point where they're getting ready to size out, but they haven't yet, and say, well, now's the time for me to sell. The problem is no buyer buys your company with the idea of keeping it the same size. A buyer wants to be able to grow your company. And if they grow your company, you're going to size out. There is definitely risk associated with going from a designation market into the full and open market.
Sure.
And the party that's going to bear that risk is going to get money associated with that. So, for instance, if a seller is trying to transfer to a buyer who's going to take on the risk of going to full and open, that buyer is going to pay less for that company. If, however, the seller says, I'm going to make the attempt at going into the full and open market, even if it's only 10%, 20%, 30% to prove that it's capable, then that seller is going to get the benefit of that increased valuation. So risk to the buyer is lower price to the seller. The seller can choose to take some of the risk out of the system and get a better price, or they could choose to try and transfer that risk to the buyer, but then the price is going to reflect that.
Yeah.
And that's part of the valuation assessment that needs to be done for these pre-estate tax planning. So if you brought us a company that was going to be sizing out, but had not yet, and has made no plans on how it was going to deal with the full and open market, that company is going to get a lower valuation than one that had already poked into the full and open market. Joe, do you have much experience with that? Have you seen that?
Yeah, I mean, I think to me that's kind of a business question of everyone's asking, how do I go from, truly set aside to full and open? How do we go from sub to prime, and then we go from small prime to large full and open, and then what do we do after that? Who do we want to be when we, you size out, you get to the mid-tier desert, and then, what happens? Where do you go? Do you transact when you kind of get there? Do you try to grow to 100? That seems to be the bogey. I've seen people get to 100 and kind of shrink back down. They haven't won some recompetes. So to me, it's always been the psychology and the drive of the owner or owner group of where do you want to go, right? And what are your objectives? Do you love the work? Are you in it? Are you doing it for the mission? Do you like it that it keeps your days full? I have owners that are 75 and are like, oh, they're going kicking and screaming, they're like, they realize it is time. But others that are saying, look, I had a client this week say my next I grew a really nice company. I have the next one lined up, and I'm ready to take some chips off the table and do something different. So to me, it's a personality question. It's a very personal question. These are closely held companies. These are not public companies. So I think finding out what it is that you want. Now, I don't think that's different. You do your planning. Your planning is in there. But to me, that has always been the question I'm looking to have answered, which is, what is it that you want to do? Where do you want to take this thing?
Excellent point. And what I see is there's a wide variation,
Yeah.
but it kind of falls into two categories. One, and I don't know where this number came from, but a lot of business owners say, I want to grow my company to be $100 million revenue company, and then I'll
Yeah.
sell. 100 million is the number that I hear on a regular
Me
basis.
too.
Then there are other folks who say, no, I've grown my company. It's 25, it's $35 million. I love what I have, but I'm ready to move on to a next stage. Those are two companies that should be thinking about doing a transaction together, assuming that all the other things work. That is, the one who is saying, I want to get out, can bring real bulk to the company that wants to get to 100 million.
True.
What you don't want to do is size out by a small amount. If you're on a NICS code that's at $34 million, the last thing you want to do is get a 5-year revenue average of $35 million,
36, yeah.
because
Yeah.
now you're competing with all the big guys
Yeah.
and you have none of the scale. If, however, before you size out, you can then acquire another company that's another $30 million, you're now a $65 million company, a heck of a lot closer to your
Sure.
$100 million goal, and having the size and scale to be able to compete more actively in that market. So
Yeah.
that's where I think that the small on small exemption in the rule could actually play a very significant
It's really
role.
interesting. I
I
think a
think
lot of owners want to buy, small owners that they do want to acquire. They don't know where to get the capital. They don't know how to do it. The size standard was a big issue, was why you just couldn't. So I think if, and maybe that's a separate webinar, right? It's like how to do that, if you're small, how to acquire, bring some financing on, some capital providers, minority interest in equity investors, Blue
Well,
Deltas of the
let's talk
world.
about that for a
Yeah,
moment, because I think that on the phone we have people who are not only sellers but
yeah,
buyers,
yeah, absolutely.
and there is a lot of capital around. If you are a credible business owner and you've been running a successful company and you have 3, 5, 8, $10 million of EBITDA, what a bank will do, and a bank is the most conservative lender, it's a senior lender. They will look at the amount of adjusted EBITDA in your company, the adjusted EBITDA of the company that you're looking to acquire, combine that and use that as a marker to determine how much will they lend. And the world does divide into different categories. If the adjusted EBITDA of the two companies is 10 million or above, you will have bankers falling all over themselves to fund that deal.
Sure.
If you are at 5 million and above, you'll have a lot fewer bankers, but there will definitely people who want to do that deal. If the combined EBITDA is below 5 million, then you've got more of a financing problem because senior lenders don't want to do that. What you can do at that point is go to some mezz lending opportunities where they might take some options. The cost of the capital will be more expensive. Or, if it's a really small deal, you can do like an SBA loan of some sort. Um, but the cost of the capital, while it looks expensive, if you're talking about mezz debt at 13, 14, 15%, SBA loans a year ago, were at 11% interest rates. So that the interest rates for this mezz debt doesn't seem quite as crazy. In addition, debt, even while you're paying that interest, is usually less expensive than equity.
Yep.
Equity, when you're raising equity, they expect 30% returns, 35% returns.
True.
So if you can get debt, you'll probably end up with more in your pocket at the end of the day. But these are the kinds of things that you really need to think through. You
Yeah.
should not be looking at in terms of, well, I don't have $8 million in my pocket, so I can't possibly buy another company. That's not the way this process works. There are people who are looking to invest in you and your ambition and your dream, assuming that they think that you've got the capability of pulling it off.
Yeah, no, I think you're absolutely right. And maybe it's a good time to transition to the capital gains conversation, because if you can build a dream, how can we actually keep more money in your pocket in that type of exit? So,
Let's do that.
all right, that sounds great. So let me bring my screen back up. Here we go. All right, so on the capital gains side, I had a lot of these questions on, how do we reduce capital gains? On the federal side, it's a lot more difficult. I'll just be candid with you. We can reduce a lot more income taxes while you're running the business. That's a separate conversation. So that's certainly doable. But on the capital gains tax on the federal side, only a handful of ways. So what are you going to pay in a transaction? So number one, you're going to pay federal capital gains that are somewhere between 20% and 23.8%. The difference in that is if you sell stock in a S corporation, S corporations, if you transact just as an S corporations, you will pay 20% capital gains. S corporation sales are exempt from the excess Medicare FICA FUTA tax of 3.8% that was enacted 8-10 years ago. Most times you're going to pay 23.8. You'll also pay state capital gains taxes, which is entirely residency dependent. You will pay state capital gains taxes dependent on where you live, not where your business resides. There are some cases that might be where the business is, but 99% of the time, it's where do you live? So what is the number one way to avoid state capital gains taxes? Everybody has had a friend who has, before they sold their company, they moved to Florida. We have helped clients move to Florida, helped clients move to Texas or Tennessee, but basically a 0% tax state. You have to live there for 183 days in a tax year. So technically, if you sold your company in March of this year and you moved to Florida in May and you got a dentist, you changed maybe your cell phone, your address, you got a lease, you bought a house, your kids are in school there, you've made true home there, you have records that you live there, you can avoid taxes. You can avoid paying the state in which you left capital gains taxes. Now, they could argue that you're not there. They could pursue it through a nexus study and say, no, you were actually connected. There's going to be a whole proof that you're going to need to come up with, get a tax attorney, but you can do that. And then candidly, that might be the easiest way to do it, but it's not the only way, okay? There are other, it's maybe a little bit more complicated, but there are other tax favorable jurisdictions that exist that interact with trust, certain types of trusts. And these trusts are called non-grantor trusts. Non-grantor trusts are forms, there's irrevocable and revocable, but basically they're trusts that have their own tax ID that reside in tax favorable states like these over here: Delaware, Wyoming, South Dakota, Nevada, Alaska. Okay, they sit over in these states. If your family lives in any one of these states that I've listed: North Carolina, South Carolina, Georgia, Colorado, Utah, New Jersey, Indiana, Kentucky, Montana, Mississippi, and a little bit California. If you live in these states, you truly do, or if you have a second home and you can live in that state officially in the year in which you sell or beforehand, preferably, we have the ability to establish a trust in a tax favorable jurisdiction over here on the left to transfer your shares of your company into those trusts. And as long as you are living in either a tax-free jurisdiction or one of these states, there is the potential to avoid all state capital gains taxes that would have been charged to you on your transaction. So currently right now, I have a client whose one owner lives in Colorado, one owner lives in North Carolina. Just so happens that's where they live. Their company they're everywhere, right? They're GovCon, they have client sites everywhere. But through this trust planning, through this planning, we are going to help them to avoid, if not most, if not all, of their respective states' capital gains taxes, which are somewhere between 4 to 5.5%. And on a big enough transaction, that can get significant. So on a $10 million transaction at a 5% tax rate, that's $500,000 of real tax savings simply by setting up some trusts. Okay. So again, yeah.
That is terrific. And again, I want to emphasize that these are very specific kinds of issues. So I would not assume that we could just take this. I think that people need to talk to you about, correct, Joe, how to do this. Jennifer, do we have any questions at this point?
I actually have questions that I think the audience might be interested in. Is private equity still investing in GovCon? Is one of my questions.
Let me take that one, if you don't mind. The answer is yes. But private equity is an incredibly broad category. So there's some private equity that's very focused on the GovCon space. They tend to invest in companies that are in the full and open market because PE really has a very hard time buying companies that have a designation unless they have a minority interest. And there are some firms that do that. Um, what I have found, particularly in the last 2 or 3 months, is that buyers, PE and otherwise, who know GovCon are actually pretty interested in deploying more capital. Those folks who were dabbling in GovCon have run for the hills. And that seems to be the cycle that occurs every 10 or 15 years.
Yeah.
People get very interested in GovCon, seeing these contracts that have 3, 5 years period of time, and the government has historically always paid their bills. And so people say, well, this is a great market, let's get in. But then they don't really understand the complexities of GovCon. And when those complexities show up, they kind of run for the hills. So the answer is PE is absolutely interested. There are some PE firms that are primarily GovCon investors, but it's a very big category. So it really does depend.
And there is a question. What kind of multiples are buyers putting on acquisitions today post Doge?
Okay, great question. What I'm basically seeing is the multiples are not necessarily different, at least at this point. But as I said earlier, I think that there's a change in structuring. That is, buyers are looking to pay less cash at close and have some increase in seller financing that can be clawed back if, in fact, there's a DOGE impact. There's basically four different risks to being in GovCon. The first is, will the Congress appropriate funds for what it is you're trying to do? The second is, hey, will there be a government shutdown? And so your folks, cannot get paid because the government doesn't have the money to pay them at that time. Third, and it's not happened a lot, but it does happen, is sequestration. We in 2010 and 2010, 2011, we had sequestration where there were flat out cuts to both the government, to both the defense and the civilian side. And then the fourth risk now is DOGE. So we've kind of incorporated the first three risks in. The fourth risk feels brand new, but I don't think it's as random as we initially thought. As I think Joe was saying before, you know, whatever it is you think is right or wrong, folks who were in the USAID foreign aid side really got hit. If you're in the DOD side, chances are you didn't get hit quite as much. So there are some areas that are safer than others, and I think buyers will be looking at that when they're going forward. If you're doing some type of very high-end AI, digital modernization, cloud migration, I think that there's going to continue to be a very active market for companies in that place.
I'll also add, I think in the Intel space, Fort Meade, Langley, anything three-letter, I mean, significant multiples still on even small business. So, I mean, those areas are very valuable.
Let me respond to a question that came in from the audience. The question is regarding the SBA 8A program as a growth strategy. What are the expectations for the level of activity, opportunities, or even continuity of the program under the present administration? Well, first of all, I'm going to start off by saying what I said at the beginning. If anybody tells you that they know exactly what's going to happen, go running from the room. Nobody knows exactly what's going to happen here. I will say that 8A is different than the other set asides. There's 8A, and there's a higher set of rules about that. And then there's women-owned, SDVOSB, hub zone, minority-owned, and just basic small business. Under the prior administration, the statutory requirement of 5% of government contracts going to 8A was tripled to being 15, and that was done by executive order. One of the first things that this administration did upon coming into office was revert that to the statutory baseline of 5%. So some 8As might perceive that as a very substantial cut, but the reality is they're at the level of the statutory protection. There would be some legal issues with eliminating the program without congressional approval. That is, I think it would be challenging to do by executive order. I'm sure there's smarter lawyers out there than me, but it is there in statute, just like the SDVOSB, woman-owned program, et cetera, as well as the overall that 23% of contracts need to go to small business. please recognize that contracts and value are totally different. That is, the number of small businesses that are out there are in the tens of thousands. But the amount of revenue that they get from the government is a smaller fraction than their numbers would indicate, not surprisingly. So the 8A program has already had a significant move from the 15% to the 5%. Don't know if there's going to be any further action, but it probably would have to happen by statute as opposed to by executive authority. And then, of course, you have the entire issue of the super 8As versus the regular 8As, because the super 8As do have some very special abilities and tend to be the acquirer of 8As that still have a lot of 8A work. Joe, any thoughts on that?
One thing I'll just add on, on the slide on pre-sale estate planning, that if there is, if you're in the standpoint of being in a very successful 8A, to the tune where you're starting to run up into some of the net worth limits, I believe it's $6.5 million of total of net worth, that pre-sale estate planning is especially effective. In that you can move up to 49%, up to 20%, actually it's up to 30% of your company now, you can move to a trust with just notifying the SBA. And that gets 30% of your net worth down. So you'll stay underneath that threshold. We've been doing that planning for quite a number of years, and it's very effective using those jurisdictions because you can get it back if you need to.
Okay. Well, listen, I want to thank everybody for their time today. I hope this has been helpful to folks. We're talking about preparing yourself and your family for the kinds of regulations and changes that are going on in the world. I want to thank my friend Joe Cope and urge people in the audience to reach out if you've got specific questions, or to reach out to me if you have questions about buying or selling. We start talking to business owners 3, 5, 7 years before they go to market. So don't feel as though I'm not ready to go to market this year. It's too early to talk. No, the kinds of changes you might need to make, whether it's to your personal finances or to the structure of your company, really do take some time before you go to market. Jennifer?
Yeah, I'd like to thank Sharon and Joe for a great discussion. And to all of you who attended, thanks for joining us. Please join us on Tuesday, May 6th for part 2 of the webinar series. We'll be reviewing more of today's discussion, as well as providing additional time for audience questions. So mark your calendar and you'll receive a link via email in the next few days to register for that. But in the meantime, if you have any questions, as Sharon said, don't hesitate to reach out to them, and their emails are on the slide. And we hope you have a wonderful day.